a foreign company can successfully register a trademark in China and still discover that the registration does not protect the business it actually operates. For example, a software company may register its name for downloadable software, but leave its SaaS platform and consulting services exposed. It has a certificate, but it may not have the protection it thought it purchased. The wrong name, the wrong classes, or the wrong filing route can weaken an application before the business even enters China. That is why China trademark registration should not begin with a form. It should begin with a strategy. In this video, I will walk you through 7 decisions foreign companies should get right before filing a trademark in China. To make the process easier to understand, imagine a foreign software company called Northstar. Northstar plans to enter China with an English brand name, a logo, a proposed Chinese name, downloadable software, a SaaS platform, and technical consulting services. At first, this may look like one trademark application. In reality, Northstar has several different protection decisions to make. The first step is deciding exactly which brand assets require protection. A business may have a core wordmark, a logo, important product names, and a Chinese language name. These assets should not automatically be treated as one interchangeable trademark. For example, Northstar could register a logo containing both the word Northstar and a graphic symbol. But what happens if the company redesigns that logo 2 years later? A combined registration may be less flexible than separately protecting the core word, mark, and important visual elements. The same issue applies to the Chinese name. Even if Northstar does not create an official Chinese name, customers, distributors, social media users, or the media may begin using one. If the company waits too long, that unofficial name may become widely recognized, or another party may attempt to register it first. Before filing, ask, what name appears on the product? What name will customers search for? What name will distributors use? And what name should represent the brand in Chinese? Those answers determine what should be protected. The second step is conducting a proper trademark search. A basic search asks, is the exact name already registered? A professional clearance search asks a more important question. What earlier rights could block, narrow, or weaken this application? For Northstar, the search should not cover only the exact English spelling. It may also need to include similar spellings, similar pronunciation, the proposed Chinese name, related Chinese characters, the logo, and earlier marks covering related goods or services. A search cannot guarantee registration. Trademark similarity involves legal judgment, and a database may not immediately reflect every recent application. But filing without searching is far riskier. Search before you invest in packaging, localization, marketing, distribution, or a platform launch. It is much easier to adjust a brand before market entry than after customers already know it. The third step is choosing the correct goods and services. This is where many applications become too narrow. Northstar does not simply sell software. It may provide downloadable software, cloud-based SaaS, an online platform, technical support, and consulting services. Those activities may not all be covered by one vague reference to software. If Northstar protects only its downloadable product, the registration may not fully cover the services through which the company actually earns revenue. The same principle applies to other industries. A consumer brand may manufacture products, operate an online store, provide repair services, and license its name to distributors. Before selecting the filing scope, ask 3 questions. What does the company sell today? How does it deliver and monetize those products or services? Where is the business likely to expand next? The goal is not to register in every imaginable category. The goal is to protect the parts of the business that would hurt most if another company used the same or a similar name. A trademark application should follow the business model, not merely the product label. The fourth step is choosing how to file. Foreign companies generally consider 2 routes: a national application filed directly in China, or an international application under the Madrid System designating China. A direct Chinese application may be worth considering when China is a priority market. The company needs a China-specific list of goods and services. A separate Chinese language trademark is being developed, or the application is likely to require close local management. The Madrid System may be attractive when the company is seeking protection in several member countries. It already has a suitable basic application or registration, and it wants to manage multiple international designations through one system. But the Madrid system does not bypass Chinese trademark law. China will still examine the designation under its own domestic rules. For Northstar, the right route depends on its wider international portfolio and how much China-specific planning the company needs. The filing route is an administrative choice. The protection strategy must still be designed for China. The fifth step is preparing the application carefully. A strong strategy can still be weakened by inconsistent application details. For Northstar, this means confirming that the applicant's legal name matches its corporate documents, the correct version of the logo is submitted, the English and Chinese marks are clearly identified, and the goods and services accurately cover its software, SaaS, platform, support, and consulting activities. The application will also need the relevant applicant information, trademark representation, classes, goods or services, and required supporting or authorization documents. Do not copy the wording from an application filed in another country without reviewing it. China may use different accepted descriptions and examination practices. And do not treat the filing form as a routine administrative document. It is the legal expression of the commercial strategy developed in the first 4 steps. After filing, the application enters examination. The authorities review whether it meets the formal requirements, whether the mark itself is registrable, and whether it conflicts with earlier rights. Possible outcomes include approval for publication, a request for correction or clarification, a partial refusal, or a full refusal. Suppose Northstar's application is refused because an earlier trademark has a similar name in a related software category. That refusal is not simply bad news. It is a decision point. Northstar generally needs to consider 3 strategic paths. First, defend. Respond to the refusal or challenge the earlier right where there is a sound legal basis. Second, adjust. Clarify or narrow the goods and services or modify the filing strategy. Third, rebuild. File a revised application, restructure the portfolio, or reconsider the brand if the conflict is too serious. The right path depends on the strength of the earlier trademark, the legal grounds for refusal, and the commercial importance of the Northstar name. It is not enough to say, our companies are different. The response must address the legal conflict identified during examination. If the application passes examination, it is published for preliminary approval. During the publication period, eligible parties may oppose the application. If no opposition is filed, or if an opposition is unsuccessful, the trademark can proceed to registration. This means preliminary approval is not the same as final registration. Northstar should confirm the official registration status before announcing that its trademark has been fully secured. If an opposition is filed, the process may take longer and the parties may need to provide arguments and supporting evidence. Registration is the result of the application process, but it is not the end of trademark protection. After Northstar receives its registration, it should focus on 3 actions. First, use. Keep dated evidence showing how the trademark is used in the Chinese market. This may include contracts, invoices, product materials, advertising, website records, platform sales, licensing documents, and distributor materials. Second, monitor. Registration does not automatically stop every later application or every unauthorized use. Monitoring allows the company to identify similar applications and potential conflicts while practical response options are still available. Third, maintain. Keep the owner's name and address current. Manage trademark licenses carefully. Make sure distributors, manufacturers, and local partners understand that they do not own the brand. And renew the registration before it expires. Registration creates the right. Ongoing management preserves its value. Before registering a trademark in China, make 7 connected decisions. 1. Decide what to protect. 2. Search before filing. 3. Protect how the business actually operates. 4. Choose the appropriate filing route. 5. Turn the strategy into an accurate application. 6. Understand examination and prepare for possible refusal. 7. Manage publication, registration, and long-term protection. The objective is not simply to receive a certificate. A trademark certificate is only useful when it protects the business you are actually building. Your trademark portfolio should support your products, your services, your Chinese brand identity, your commercial channels, and your long-term plans in China. In the next video, we will examine what happens when Chinese consumers create a name for your brand before you do, and why that unofficial name can become both a legal and commercial problem. If your filing involves multiple brand elements, a Chinese language name, or several business activities, the strategy should be reviewed before the application is submitted. Subscribe for practical guidance on China trademark protection, intellectual property risks, and market entry strategy. This video provides general information and should not be treated as legal advice for a specific application.